at summary judgment, it's a very effective tool for a plaintiff. It can only be used in very specific circumstances. There's a few requirements. The plaintiff has to have filed his written statement of claim, and the defendant has to have given notice of intention to defend the claim, or he may even have filed his defense to the claim. So the idea behind the process is that it enables a plaintiff to obtain quickly a final judgment in the proceedings where the plaintiff says that the defendant does not have a proper defense to the claim. Now, a successful summary judgment application is very advantageous for a plaintiff as it avoids the substantial costs and delay of going to a full contested trial. As you can imagine, a full trial will usually require extensive discovery of documents. There will be multiple witnesses and corresponding witness statements. You may have to instruct an expert witness. And on top of all of that, you will usually have to instruct senior and junior counsel to conduct the trial. And that is another very hefty layer of additional fees for counsel's brief fees. So in any event, once a plaintiff has applied for summary judgment, this is an important point. The onus then shifts on the defendant to show that there are triable issues or that he has an arguable defense. Now, that is very different than a defense that actually has merit. In practice, it's usually not very difficult for a defendant to show that there are triable issues on the pleadings or the affidavit evidence, as the threshold is not very high. Now, for this reason, summary judgment should really only be used in very limited circumstances. Really, we're talking about very straightforward cases where it's clear the defendant has no proper defense, i.e. that there's no triable issues. The bottom line is, on a summary judgment application, the court won't want to have to delve into complicated factual or legal issues. And if it does, the chances are that the summary judgment application will be unsuccessful.